Mr. Jaffe.
My lords, my lady, following the introduction I gave before the short adjournment, I propose to make 5 points. First of all, if I may, I'll deal with the facts. Secondly, the law. Thirdly and fourthly, the 2 grounds of appeal. And then finally, I'll briefly address the position if the Commissioner is wrong about the grounds of appeal and whether, if the grounds of appeal are made out, they are material to the outcome of the case. As I've already said, my lords, my lady, none of the facts as found by the First-tier Tribunal are an issue in this appeal, and there were in fact very few disputes of facts before the First-tier Tribunal. As my Lord Justice Newey has already pointed out, there was a schedule of agreed facts which was before the Tribunal. I won't take the court through it, but for the court's note, it's in the core bundle. It's in the supplemental bundle, I apologise, at page 173. And the upshot of the agreed facts is that there was a concession of a breach of Articles 13 and Article 14 of the GDPR. And it was also conceded that a large number of pieces of paper were found outside in the yard at the appellant's premises in unlocked crates, boxes and bags, and it was conceded that at least some of those documents contained not just personal data but special category data, in this case medical personal data. So the issues of fact which were before the First-tier Tribunal were the circumstances in which that material had been left outside and the length of time for which it had been left there. And it was the position of the appellant that the location where this material was stored was sufficiently secure and was an appropriate place for its storage, which perhaps not surprisingly was rejected by the First-tier Tribunal. And secondly, the evidence of the director was rejected that the material had only been there for a short time. The conclusion of the judge, which she reached, as she said, on the balance of probability, because it was impossible to be certain, was that it was likely that the material had in fact been left outside for a long period of time. And that was, of course, taken into account. And that is then set out in the tribunal's judgment in passages which, again, the court will have seen having read it, and I'm not going to go through. Those were the findings of fact, and they're perfectly sensible, and they're unappealed, and it was properly conceded by my learned friend, Mr. Cockle, this morning, that in particular paragraphs 81 to 87 of the judgment of the First-tier Tribunal were findings of fact that were final and to which no challenge is made or brought. So what did that mean for the case? Well, the basic case that was being put forward is that the outside yard was a secure place and therefore there was no difficulty, at least in the temporary storage of materials there. But once it was accepted that the material had been there for a significant period, and once the judge had made findings of fact that there was in fact access for other people through the fire exit of adjoining buildings, and once the judge had concluded that this was not an appropriate level of security for this type of information, there was a clear breach of the principles. And as to the severity of the breach of the principles, there is no challenge to the fact that the material had been there for a substantial time. Now, as to the severity of the case, there were some submissions that were made this morning, which I submit were inappropriate, as to the severity of the breach. There was a certain amount of poo-pooing. There were reference to sealed bags of documents There was reference from my learned friend to the idea that we all needed to get real. With some degree of criticism or disbelief, it was suggested that there could have been any emotional distress as a result of this breach of data protection standards. Just on that, could I ask the tribunal, ask this court to look at the confidential bundle briefly, which is material that was before the first tier, just by way of illustration of the types of material that were involved. If I could ask the court to have a look at page 2 of that bundle. These are extracts from the larger bundle before the First-tier Tribunal. One sees an NHS prescription form in what for most of us will be a familiar format. The name of the patient's address, and the date of birth have obviously been blanked out. But left in is the prescription. The prescription in this case is for an early stage Alzheimer's drug. Of course, knowing what drugs people have had prescribed for them is itself sensitive special category data, because it discloses their medical treatment and it discloses what medical condition they suffer from, often life-altering information. Page 3 is a prescription of a strong opiate for long-term use. Page 4 is an antipsychotic drug.
Quick appeal.
Yes. As for the security of the storage of documents, the position is illustrated by looking at page 16. And these are the photographs taken by the MHRA during the execution of their search. Materials were found in open boxes and containers, which can be seen on pages 16 and 17, or in open, straightforward cardboard boxes, which can be seen at page 18. For me, at least, working electronically, on page 18, it's possible to look at the top 2 documents, the top 2 prescription forms on page 18, and they are for controlled opiates. Pages 20 and 21, one sees further boxes, and at 21 we have open bin bags full of this material. We do respectfully say there is no particular role in this case for issues about the burden of proof. The tribunal saw all the evidence for itself and reached its own conclusions, most of which were made by way of admission. Returning then briefly, if I may, to the First-tier Tribunal's decision to look at how the learned judge approached the question of penalty. In the core bundle at page 185, the monetary penalty notice is dealt with from paragraph 88 onwards. What the judge has done is the judge has obviously carefully read and analysed the Information Commissioner's reasoning in the notice, and with notable exceptions, the most notable being the reduction of the penalty by 2/3, has accepted the Commissioner's analysis of the severity of the breaches, having heard and seen all of the evidence. So at paragraph 89, if there is any question of whether the judge is exercising her own independent judgment, she says, "I nevertheless reach the same conclusion as the Commissioner, in that the contraventions identified are sufficiently serious to justify issuing a penalty." And then, in contrast to the Commissioner, the breach of Article 24 is improper. It's not one which can form the basis of a penalty. And then paragraph 90, the judge adopts the Commissioner's assessment of the factors other than the assessment of the number of data subjects. So it was in no sense being accepted uncritically. The next sentence, the judge notes in particular the Commissioner's conclusions as to the gravity of the breach and the risk of significant emotional distress being caused to a vulnerable group of data subjects, and then says that she agrees with the Commissioner's conclusion that the serious breaches were largely due to Doorstep's negligence in relation to its obligations. So again, there is a clear statement of independent consideration being given to the Commissioner's conclusions and whether they're right or not. Then paragraph 91, the judge's conclusions are set out, that issuing a notice is effective, proportionate and dissuasive response. And then in 92, the judge notes the statutory scheme and the intention that penalties were meant to be higher, considers the Commissioner's guidance and the circumstances, and then concludes that I am satisfied, that is, the judge is satisfied, as to the penalty that was imposed, including the making of a significant reduction in light of Doorstep's financial position. And then paragraphs 93 and 94 start with words like I agree and I am satisfied. Then paragraph 95, given the gravity of the contraventions, my additional finding that Doorstep is responsible for a breach of Article 5.1e and the long list of aggravating criteria, the penalty shouldn't be reduced by a simple percentage. And then there's a conclusion of paragraph 96 as to what the penalty ought to be. So there's no evidence whatsoever of inappropriate deference or unwillingness to make a robust finding. This is obviously unwelcome to the Information Commissioner about what the outcome ought to be. So that's my first submission, my lords, my lady, on the facts. Turning secondly to deal with the law, I can deal with this relatively briefly because the court has of course already seen most of the legislative structure, but with apologies for asking you to do it, can I ask you to go back to the GDPR, which is in the authorities bundle at tab 3, page 64.
Page
64, my lady.
tab 3 for me stops at page 75.
Tab 2.
I'm sorry, tab 2.
You.
And at the bottom of page 64, I hope the court have Article 5, which sets out the data protection principles. And the relevant ones here are over the page at page 65 at E and F. At E, we have the duty to keep information in a form which permits identification of the subject for no longer than is necessary. So, in other words, a duty to delete or anonymise once you don't need it anymore. And then F, to process in a manner that ensures appropriate security of the personal data, including protection against unauthorised or unlawful processing, accidental loss, destruction or damage, using appropriate technical or organisational measures. So those are the basic obligations. They are then supplemented at 2, Article 5.2, by a relevant provision when we look at the authorities on burden of proof. And Article 5.2 explains that the controller shall be responsible for and be able to demonstrate compliance with paragraph 1, which is the principles. And that's known as the accountability requirement. Now, I raise that because this is not some unusual artifact of retained EU law. It reflects a similar provision which one can see in many other UK regimes, such as the tax regime, to be able to demonstrate evidence of compliance with a regulatory scheme. So a significant factor for Lord Justice Carnworth in Carn, and we'll get to it in a moment, was that taxpayers are required to keep appropriate records so that they are able to demonstrate their compliance with their tax obligations. just as there, that is the duty of taxpayers, here it is the duty of data controllers to do exactly the same thing. So far from the schemes being fundamentally different, our submission is there is a key similarity. Then over the page at page 66, we have articles 13, and then at page 67, articles.
Forgive me, do you say that Article 5.2 impinges on the question of burden of proof in the FTT?
Yes, it's relevant because one of the reasons which Lord Justice Carnworth in Carn said that there was nothing wrong with imposing a burden of proof on a taxpayer to be able to explain what the correct amount of tax was as part of their appeal, because you have a duty to keep appropriate records on tax legislation. As here, it is the duty of a data controller to be responsible for and be able to demonstrate compliance with the principles. So it's the duty of the data controller not just to comply with the principles, but also to be able to demonstrate their compliance.
Does that operate in practice during an appeal? So if an appellant brings an appeal, at what stage, if at all, does someone turn to them and say, but under Article 5.2 you are responsible for demonstrating and you haven't?
That could be a basis for a monetary penalty notice. It was not in this case. So it was not a substantive issue which arose in this case. But where it does become relevant is because it shows, we say, the similarity between the issues in Carn and the issues here. And that's why ultimately we say that these circumstances are on all fours with Carn, and it's not one of those special cases where there's something about the statutory scheme which requires you to adopt the opposite approach to burden of proof.
So you don't rely on Article 5.2 as such as being a sort of exocet that demolishes Mr. Coppell's submissions on burden. No, thank you. No, thank you.
We just say it's one of the relevant factors which we to Carn. We then have Articles 13 and 14. There were some submissions made by my learned friend Mr. Coppell that, whilst this error was regrettable, it occurred in the context of the introduction of the GDPR and everyone doing their best to comply. There are more or less identical obligations to Articles 13 and 14 in the old First Data Protection Principle in the 1998 Act. So it didn't really come as any great surprise, there was just a breach of it. Then turning on, if I may, to page 73 in Article 25. There are further obligations. And Article 25.1 requires that, having taken into account the state of the art and the cost of implementation and the nature, scope, content and purposes of the processing, the controller shall implement technical and organisational measures which are designed to implement the data protection principles. So in other words, you have to have an arrangement or a policy or a procedure, bearing in mind the cost and the difficulty of implementation and the state of the art and so on, to ensure that the principles are in fact complied with.
And just echoing my Lord's question a moment ago, where does that take one here? Because you're not alleging breach of that.
Well, I think there was certainly a breach of Article 32, which is similar provisions relating to security, which I'm coming to now.
Yes.
Article 32 is on page 74, and it's essentially identical provision relating to security, taking account again of the state of the art, the costs, the nature, scope, content, purposes, processing and so on. You have to implement appropriate technical and organisational measures to ensure a level of security appropriate to the risk. And that obligation, as the Commissioner and the First-tier found, was not complied with. Now, that's also relevant to some of the submissions made by my learned friend about, for example, cases separate from this one. such as cases where a large company, British Airways was mentioned, have their computer systems hacked. And it was said it would be terribly unfair to impose a burden of proof in an appeal on British Airways or a company in a similar position, because we were talking there about the conduct of third parties who would not be before the court. Now, with respect, that submission is completely wrong. The breach in that case, and in those circumstances, by a company like British Airways, is a breach of, for example, Article 32. It's not a breach of data protection requirements if some third party hacks your computer system of itself. There are bad actors in the world who do bad things. Crimes are committed. The breach comes if, taking account of the state of the art and the cost of implementation and so on, you don't have adequate security in place to prevent that. And the way those cases always work out is the allegation is that you left either the front door or the back door unlocked in an electronic sense, or you didn't have adequate procedures in place to ensure that a type of attack which was entirely foreseeable could not succeed or was stopped before it did succeed. And those are issues, of course, which are uniquely in the knowledge of the data controller. British Airways, or whichever local authority it is, knows how their own computer systems operate. They know what technical precautions they have put in place and what safeguards exist to prevent realistic and likely attacks. And therefore, if they disagree with a monetary penalty notice that they failed to take reasonable care, then they are in a position to prove the relevant facts in order to show that. So we respectfully disagree that the interpretation of the legislation on the burden of proof that the Commissioner advances to this court is one that will have terrible and unfair results in other cases, and therefore can't be correct. Just before moving on from the GDPR, if I could just make good the points I made before the short adjournment about independence. At tab 3, page 75, there are the provisions about the status of the Commissioner. Article 51 gives the Commissioner responsibility for monitoring the application of this regulation in order to protect fundamental rights and freedoms. And then Article 52, sub-article 1, the Commissioner's duty to act with complete independence in performing tasks and exercising powers. If that's not clear enough, there's 52.2. The Commissioner shall remain free from external influence, whether direct or indirect, and shall neither seek nor take instructions from anybody. Those provisions are in particularly clear and strong terms when one compares it to the position of many other regulators who are subject to, for example, statutory direction powers from the Secretary of State, which are very common in the case of other regulators. This is a Commissioner, because of his role and the origin of his role in EU law, which requires a particularly high degree of independence for his decision making. And so the idea that an independent court reviewing a decision of an independent decision maker might wish to read and carefully take into account what that independent decision maker has said and done is not particularly surprising, we respectfully suggest. Only, of course, if the independent court, the First-tier Tribunal, thinks it probative, relevant and correct. That brings me then, my lords, my lady, to the provisions of the Data Protection Act itself.
Just to be clear, Article 57 dealing with tasks doesn't take things any further, or nor indeed does anything else in this section.
I don't think so, my lord. So if I could ask the court to go back to tab 1 and look at provisions that I'm afraid we're probably all too familiar with, starting at page 29, section 155. Section 155 deals with the imposition of a penalty notice at the stage of the Commissioner. And when the Commissioner is deciding whether to make a penalty notice, there's no doubt that the burden of proof is on the Commissioner. That's clear from 1551, if the Commissioner is satisfied.
Is it meaningful to talk about a burden of proof in those circumstances?
Not especially, but the Commissioner does have to be satisfied.
The Commissioner has to think it is the case.
Yes.
But I mean, the burden of proof suggests that she has to prove it to herself.
Yeah,
it sounds
it's
very
not
strange.
it's not a
concept.
contestation between two people where there's an adjudicator, but the Commissioner has to be satisfied that on the balance of probabilities that the facts as found in the notice are the facts. So the documents were left outside in a yard to which other people had access through a fire escape, for example. The Commissioner would have to be satisfied that that fact was true on the balance of probabilities. So in that sense, there is a burden of proof, although I agree it's slightly inapt in the context of a regulatory decision.
It's inapt because burden of proof is a particularly adversarial concept, isn't it? It's if you've got two people at loggerheads or in dispute, who bears the burden of proof? What we're talking about here is different. It's not a burden of proof as such, although I would at least provisionally agree with you that the Commissioner has to be satisfied on the balance of probabilities that A, B and C, otherwise she's acting wrongly.
I mean, a judge finding facts doesn't have a burden of proof. They just have to think it's likely.
It's just not the time to use that language, it seems to me.
I do understand what my lord is saying, but the satisfaction, I'll put it no higher than the Commissioner does have to be satisfied of the relevant facts and would be acting improperly if the Commissioner wasn't, and the satisfaction is on the balance of probabilities. Put it no higher than that. Then under 155 subsection 3, there are a list of mandatory relevant considerations when considering the question of penalty. And we've all looked at those before, and there are a series of obvious points about nature and severity of the conduct.
But I think Mr. Coppell told us that this list was not as such relevant here because this is dealing with a different type of matter. We looked at the equivalent list in Article 83, do we?
Yes, and I think that's correct, but the list is in
Yes, that's
materially identical terms, so it doesn't really matter. There are then, and we don't need to go through them, procedural fairness requirements before a notice can be made. They're in Schedule 16. There has to be a notice of intent. The notice of intent has to contain the Commissioner's reasons and relevant findings of fact. The Commissioner has to give at least 21 days for a response in writing. There's a power to direct an oral hearing, and there's a duty to consider the representations that are made. Again, I won't go through it, but it's page 58 of the Bible. And then if the data controller is dissatisfied, a notice having been issued, there is a right of appeal to the First-tier Tribunal. And with apologies for going back to it, hopefully for the last time, they're the provisions in section 162 and 163 at page 36. Section 162 creates the right of appeal, and the relevant one is 162(1)(d), an appeal to the tribunal from a penalty notice. And then under subsection 3, a person who's given a penalty notice may appeal to the tribunal against the amount of the penalty specified in the notice, whether or not they appeal against the notice itself. So it can be an appeal on the merit, on the substance, or it can just be a penalty appeal. And then the critical provision we respectfully suggest is section 163, dealing with the determination of appeals, which is the heading. Subsection 2, and the first provision that's relevant, is the tribunal may review any determination of fact, and then this, on which the notice or decision against which the appeal is brought was based. So, what is the review of? Not any determination of fact, but only a determination of fact on which the notice was based. In other words, a material determination of fact. that language itself, we respectfully suggest, shows the enormous difficulty with the appellant's argument that one starts from a blank sheet, ignoring the decision made by the Information Commissioner. Because the First-tier Tribunal's jurisdiction, when it comes to looking at questions of fact, is a review of a determination of fact on which the notice was based. It's very clear, we say, textual indication that what one is doing is one is looking at the determinations of fact which were made and on which the decision was based, and then analysing on the basis of what may be much more complete and better evidence, in essence a trial, as to whether those determinations of fact are good or bad ones. The next provision is subsection 3. If the tribunal considers that the notice against which the appeal is brought is not in accordance with the law. So the basis on which the appeal is allowed is that the notice does not comply with the law. Now, in order to make such a finding, one has to, again, we say, analyse the notice. One has to look at it and see whether or not it is in accordance with the law. And one will give reasons why it is or it isn't. And then 3b, to the extent that the notice, one has to read it again, involves an exercise of discretion by the Commissioner. So is this a case where the notice involved an exercise of discretion, that the Commissioner ought to have exercised the discretion differently? So it is essential to any analysis under 3b that the reasons given by the Commissioner for exercising a discretion in a particular way have to be analysed by the First-tier Tribunal in order for the First-tier Tribunal to decide whether or not the Commissioner ought to have exercised that discretion differently. That is not to say that the First-tier Tribunal starts with any kind of thumb on the scales or any predisposition that the Commissioner is right. It's just that this is in the nature of an appeal. And the nature of the appellate role involves an analysis of what has gone before.
You're putting it in very slightly different language, but as I understand what you're saying, you're putting it in much the same way as I put to Mr. Coppell this morning.
Broadly, yes, man.
Broadly.
Yeah. I think in essence we're making the same point.
But if I got anything wrong, please say. That may take time.
No, I don't think so. Now, as the court has already noted, materially identical language is used in the immigration and asylum legislation. First of all, in the 1999 Immigration and Asylum Act, but also in the successor legislation, which has applied subsequently. And just to identify what the differences are and why those differences are not material, could I just invite the court to have a look at tab 11 of the authorities, that's page 104. So at paragraph 21 at the bottom of page 104, at A, not in accordance with the law, and then this is added, or with any immigration rules applicable to the case. The reason that's there is because the immigration rules are technically not law, they are a policy, which is issued by the Secretary of State, albeit a policy which Parliament intends to be binding and therefore allows as a basis of an appeal. And then over the page at page 105, at the top we have B, the exercise of a discretion, which is materially identical. And then at subparagraph 3, the adjudicator may review any determination of a question of fact on which the decision or action was based. Now the ordering is different. I mean, in our legislation it's first rather than afterwards, but the text is again materially identical. So that's the law. Turning then, if I may, to my third topic, which is the burden of proof. we say that the key points are these. The first is that before the first-tier tribunal, the burden of proof is a concept that is only relevant to findings of fact. There's no burden of proof on issues, for example, of law. The law is what the law is. So it is a legal principle and a technique for resolving disputed issues of fact in the contestation of a contested hearing, and enables a default position to be adopted. The second point is one which is again obvious, that the standard of proof is the civil standard, the balance of probabilities.
So that was in dispute, but is
but
not
no
pursued
longer.
now.
Now, in cases decided to the civil standard, especially after a trial where the parties rely on documents, call evidence and so on, as we all know, the burden of proof is only very rarely significant, because it is ordinarily possible for a judge to make findings of fact on the evidence, even if the evidence is incomplete and even if there are uncertainties, because part of the judicial role is to say what is more likely than not. So the burden of proof is in reality only relevant in a limited number of scenarios. One is if there is no evidence before the tribunal at all on an issue, then the burden of proof will be relevant. And by evidence, of course, I don't mean, as sometimes the appellant means, a witness giving oral evidence and being cross-examined. By evidence, I mean any admissible evidence which is before the tribunal. And the strict rules of evidence do not apply in the tribunal. It's not a criminal trial. There's no hearsay rule. Matters don't go to admissibility. They generally go to weight. The other situation in which the burden of proof may be relevant is if the tribunal truly cannot make an assessment as to what the facts are on the balance of probabilities, because the evidence before it is so finely balanced, it's impossible to make a judgment. And again, that only occurs in rare situations, and we are very far from that situation in this case. The third point is that if there is no appeal from a notice, the decision becomes final and it can be enforced. The decision of the Information Commissioner is a final decision unless someone brings an appeal and succeeds in that appeal. The fourth point is that on an appeal, where someone does want to challenge a notice, we say as a matter of well-established principle that it's the appellant appealing a regulatory decision to bear the burden of proof where they wish to establish additional or different facts. In other words, what that means in practice is for an appellant to draft grounds of appeal, setting out the facts that they invite the tribunal to find, and then adduce evidence in order to support or prove those facts. And of course, that's reflected in the first-tier tribunal rules, as was put to my learned friend, Mr. Coppell, this morning.
Just digressing briefly, the first tier didn't give any relevant directions here procedurally before the trial.
I wasn't instructed in the trial. May I turn my back and ask Mr. Lockley to check that? There may have been some ordinary case management directions. We'll check that and come back and answer my Lord's question if I may. Then, finally, it's only where the legislative scheme indicates to the contrary that a different approach to burden of proof will be reached. And such a conclusion might be reached either as a result of express words, and there were such express words, for example, in Khan, relating to certain aspects of the burden of proof, or it could be by implication, where, understanding the scheme as a whole, Parliament must have intended a different burden of proof to apply. And we say there is no express basis for such a conclusion here, and there's no basis for such an implication. The basis for that is an analysis of three authorities. First of all, Khan. Secondly, Hope and Glory in the licensing context. And thirdly, Awards Drinks, which is another VAT case. All of those cases are cases decided in this court. So first of all, if I may, Khan. I know the court have read it, so I'll take it relatively briefly. It's in tab 13 of the authorities, page 122. And the factual complexity of this case was that Mr. Khan didn't register his dry cleaning business for VAT. A penalty was imposed on him on the basis of his dishonesty, and the revenue made an assessment of his liability. And he challenged both the penalty for dishonesty and the quantum of the assessment that had been made against him. And the holding of the Court of Appeal was that the burden of proof was on Mr. Khan to prove the facts he relied on in support of his appeal, with the exception of the question of dishonesty. And the exception was because in that case there was an express statutory provision reversing the burden on the issue of dishonesty only. And then it was said, well, even on that issue, the burden of proof is not terribly important because the tribunal in that case had, after all, made a reasoned finding that he was dishonest, which was a perfectly proper finding based on the extensive evidence that the tribunal in that case had before them, and also a logical inference from the facts as they found them. So, if I may, picking it up, first of all, at paragraph 7 of the judgment. At paragraph 7 at the bottom of page 126, in the second sentence, Lord Justice Carnworth mentioned the obligations relating to the keeping of records and making of returns imposed on taxable persons. So that's the reference to the statutory scheme requiring records to be kept by taxpayers, to which we have an equivalent, we say, in Article 5.2 of the GDPR. And as was referred to this morning, paragraph 10 sets out the reverse burden provision, which is expressed in the legislation. So that in any case where, for the purposes of evading VAT, a person does an act or an omission, and the conduct involves dishonesty, they're liable for a penalty. And subsection 7 provides that the burden of proof of those two issues lies on the Commissioner, not on the taxpayer. The way this case went is of some interest because the learned judge below, Mr. Justice Hart, concluded that the burden of proof was on Customs in relation to all of the issues. And that is recorded at paragraph 63 on page 139. And then at page 140, paragraph 67.
Paragraph 63, let me just identify it.
Was it 62 or 63?
I think 63. Before Mr. Justice Hart, there was no dispute that the tribunal had correctly placed on Customs the burden of proving dishonesty. And then 64, Mr. Justice Hart accepted the burden lay on Customs to show that the VAT threshold had been exceeded, but he thought the point was academic because the issue just didn't arise because the tribunal, the commissioners have made, the tribunal have made perfectly good findings of fact based on the actual evidence.
Yeah.
Then before the Court of Appeal, the position is set out at paragraph 67. Counsel for Customs conceded that the burden of proof lay on them, not only to show that the appellant had exceeded the VAT registration threshold, but also to establish the quantum of tax evaded. So the contrary position was conceded. And then paragraph 68, perhaps this is related to the fact that Lord Justice Carnwath was previously junior counsel to the Revenue for many years. The concession is rejected, even though it's made by all parties, and Lord Justice Carnwath then goes on to explain why the concession made by Customs was wrong. Paragraph 69 explains that the law is well established in the context of VAT, that the burden lies on the taxpayer to establish the correct amount of tax due, and then cites the relevant authorities. And then at paragraph 71 deals with the position in other statutory contexts, particularly where the relevant facts are peculiarly within the knowledge of the person appealing. Now, of course, that's the relevance of Lord Justice Carnwath's citation at paragraph 7 of the obligation on taxpayers to keep proper records, because the facts are therefore, or at least should be, peculiarly within their knowledge. And the same applies, we say here, as a result of Article 5.2 of the GDPR, and also the basic fact that the compliance with obligations to secure the security of data are matters that are particularly within the knowledge of the data controller, rather than the information commissioner, or at least they ought to be. And then Lord Justice Carnwath gives examples of paragraph 71 of the authorities relating to planning control, citing the leading case in that context, which is Hill and the Secretary of State for Transport, where the point is put firmly by Lord Justice Buxton in the quotation. And then paragraph 72, it's true that these were planning cases, but the statements in the former were expressed generally. There's then a case cited to the contrary, which is Traffic Commissioner and Muckett, but that resulted from the interpretation of a European directive on which the regulations were based. The statement of basic principle is set out at paragraph 73, which is that the ordinary presumption is it's for the appellant to prove his case, and that's the correct starting point. And the burden rests with the appellant, except where the statute is expressly or impliedly provided otherwise. And then finally, the appeal was rejected at paragraph 77.
I wonder whether some of 74 is actually relevant.
Yes, there are a list of factors which are taken into account.
But especially factor 6, I think you might say, has a resonance.
Yeah, and also factor 1.
Yes. Maybe 1 and 6 go together to an extent. I'm not
Yes,
sure.
so they're really aspects of the same point. So that's just a more detailed explanation from the judge as to why it's a perfectly fair and appropriate outcome in circumstances where you have maybe taxation is not to be called a regulatory scheme, but a scheme of control and obligations imposed on people which require them to keep information to enable fair assessments to be made. Applied here, we say there's nothing to displace the ordinary principle identified in Khan, and if anything, there are provisions which indicate that the same approach ought to be taken. Article 5.2, the obligation to be able to demonstrate compliance. The position is on all fours. So that's Khan. The second case is Hope and Glory, which is in tab 12 of the authorities. This is a decision of the Court of Appeal which postdates Khan, which deals with the burden of proof in a regulatory context, but unfortunately Khan doesn't appear to, well, it's certainly not cited in the judgment, and I'm afraid we don't know from the report whether it's cited to the court. The position on burden of proof is, I think, accurately set out in the head notes at holding number 2. And on page 108, between letters E and F, it said it was normal for the appellant to have the responsibility of persuading the court that it should reverse the order under appeal. And the magistrate's court's rules indicated that was so in the case of statutory appeals to the magistrate's courts. And then it's explained why that makes good sense in the context. The relevant part of the judgment is on page 120, paragraph 48. Which really states the principle in more or less the same way as Khan, without referring to Khan. So that's a much less detailed analysis of the approach to burden of proof than one gets in Khan, with much less citation of authority, but nonetheless it's the Court of Appeal reaching essentially the same conclusion and identifying for itself more or less the same test. And then finally we have the more recent decision of the Court of Appeal in the awards drinks case, which is at tab 25, page 428. The essential underlying issue in this case was whether a UK company which operated what I'll call booze cruise warehouses in France that one could go and buy alcohol in bulk in has been engaged in VAT fraud. And the finding of the First-tier Tribunal in that case was that the entire business of the company was in essence fraudulent and designed to evade VAT obligations. And the First-tier heard evidence from the director of the company and found it entirely unsatisfactory. So if I can pick up the judgment at paragraph 15, which is on page 434. Having quoted over most of that page the First-tier Tribunal's findings, some surprise is expressed by Lord Justice Henderson that the case proceeded any further. Then there's citation of Lord Justice Calmer's judgment in Khan. This is the top of page 435. The burden was firmly on award to displace the assessment, and no substantial case has been put forward. The only evidence that was put forward by the director, Mr. Judd, has been rejected. Indeed, at the end of paragraph 15, it was said that his credibility was left intact. So then at paragraph 16, there was no basis to show that the assessments made by HM Customs and Revenue were incorrect. So Khan is cited and then applied. And then Khan is again dealt with later in the judgment in more detail. Paragraph 28 on page 438. At paragraph 28, Khan is cited again. And then Lord Justice Henderson goes on to cite other cases in the tax context, reaching the same conclusion in respect of different taxes.
So we've shifted from the VAT regime to direct tax, I suppose.
Yes, and so the next case that's cited is the Group Lotus case, at paragraph 29, which concerned corporation tax. And I won't go through it in, again, too much detail, but at paragraph 33, the court concludes that the position is the same in relation to direct tax. And then I think it's also worth looking at paragraph 34, because in that direct tax case, and this is quoted by the Court of Appeal and Awards against Lord Justice Mustill, discussed the potentially misleading concept of a shift in the evidential burden of proof. And then there's a long quotation of Lord Justice Mustill's judgment in that case, where in essence he says that's not a helpful concept. Now, that may well be relevant to the way the First-tier Tribunal here put it, that there was an evidential burden which shifted. And whilst one can entirely understand what they were saying, the practical realities of proof are that someone is going to need to adduce some evidence of something which they can adduce evidence of. That's not necessarily a helpful concept, and it's important to distinguish it from what the legal burden of proof is, which is the issue with which we're concerned in this appeal. So that's a case citing Khan, applying Khan recently, and also noting that it extends across the piece in respect of tax appeals. So for those reasons, we say that the burden of proof, to the extent it arises at all, in this appeal, is on the appellant, and there is no basis for saying that the ordinary principles and approach ought to be displaced. That's ground one, unless I can assist the court further on that. I turn then, if I may, to ground two, which is the relevance of the Information Commissioner's notice. What is said by the appellant is that really there's something inappropriate in looking at, and even where it's thought to be persuasive, a tribunal paying attention, to the extent the tribunal thinks it's appropriate, to the decision and the reasons given for the decision by the Information Commissioner. We say that's wrong, and looking at and paying attention to and taking into account, to the extent it's thought to be persuasive, a decision of the Information Commissioner does not mean that the First-tier Tribunal has gone wrong in some way, still less that the appeal to the first tier has not been conducted properly, or that there's a tilted balance, or that the tribunal is predisposed to upholding the decision under appeal, or that there's some kind of appearance of an inadequate appeal or anything like that. It certainly doesn't mean that the Information Commissioner starts with any kind of advantage. What it does reflect is that on some issues, the reality is it is likely to be some issues alone, a tribunal may wish to give the assessment of the Commissioner, particularly on an area where the Commissioner has particular expertise, some weight. Now, that is seen in this case solely on the issue of penalty. And of course, that's a classic area in which the judgment of the Commissioner might well be of assistance to the First-tier Tribunal.
Why?
And that's because penalty involves making an evaluative and comparative judgment, and it involves an assessment of what is necessary in order to achieve, across a regulated industry, that is people who use data, effective deterrence, and to have an appropriate dissuasive effect on, first of all, this data controller, and also on other data controllers.
Do we have any information or knowledge about whether, for example, the Commissioner keeps records and so can audit itself for consistency and things like that?
Well, monetary penalty notices are published, and they're available. They're generally available, and so when these cases are argued in the First-tier Tribunal, it's very common for everyone to come along with a sheaf of previous notices and say, well, This decision here is completely out of line because look at this comparator and look at that
A
comparator.
bit like old-fashioned procedure in relation to personal injury claims.
Yes.
Look at these claims for loss of a leg. Where it comes to the same thing,
And then everyone tries to distinguish them and say, well, that's
course.
not similar because
one
this
way or
person-
the other.
And since the proposition strikes me as a significant one, can I just go back to what you were putting forward as the proposition?
Yeah.
There may have been more than one sentence to it. I think you referred to an evaluative and comparative exercise or some or assessment or something along those lines. I don't know whether you've got this written down, so you can give me the precise wording.
What I was doing is I'm solely giving an example
Yes.
of a type of situation in which a judge of the first-tier tribunal might wish to take into account, and would be acting entirely properly in taking into account some of the analysis of the commissioner. I'm not saying it's limited to those situations, or that a first-tier tribunal would do so. They may say, I've read this analysis, I'm afraid I don't think very much of it, and I think this ought to be the penalty, thank you very much. But there are circumstances, for example, where the commissioner says, well, I do think that penalties of this order or of this level are necessary to achieve an appropriate level of deterrence and a dissuasive effect. And it's perfectly open for a first-tier tribunal judge to say, well, the commissioner does impose these penalty notices and does have an understanding across the piece of the position, and I don't think there's anything wrong with this analysis or this is out of line.
So you're not contending for a sort of inherent status,
No.
in the same way as is sometimes accorded to planning committees, who are given, because they're the repository of the democratic process and things like that,
No,
given a sort of special. You're simply saying, in an appropriate case, when confronted by reasoning which is persuasive, it's open to people to look at and adopt that reasoning.
yes.
Are you going a little bit further than that, in the sense that you're saying, well, the Information Commissioner can be expected to have expertise, a wider picture? So it's not just the tribunal looks at it and thinks, oh, well, I agree with that. They are, you would say, entitled to attach some weight to the fact that the Information Commissioner, with the expertise, has formed that view.
If the tribunal wishes to. I'm not saying that they are required to do so. I'm saying that they are not acting unlawfully if they do so. I certainly don't suggest they need to do so in every case, and I certainly don't suggest that there is some status, that being the commissioner has, which means that this will be the outcome. But that is a conclusion which a first-tier tribunal is entitled to reach. Now, my learned friend's riposte to that is, well, look at who's appointed to the first-tier tribunal. You have to have specialist knowledge of data protection, and that is absolutely right. But this is not a question about the relative competence or skill of the Information Commissioner versus a first-tier tribunal judge. What this is about is it's about, for example, in the case of penalty, that when assessing penalty, the Information Commissioner is in a particular position of deciding all of the cases and having an overview of the entire use of data across the United Kingdom, which is, of course, his statutory obligation under the GDPR. And that is a relevant factor which a tribunal can take into account. And I'm about to turn to it, but that is the analysis one sees in the 3 House of Lords or Supreme Court decisions in the immigration context that have been referred to by the parties. It's not about the inherent status of the decision maker, but it's about particular factors which may be relevant in particular circumstances.
And just before you turn to the authorities, going back to the statutory scheme and so on, you were referring us to the statutory provisions as to independence and so on. But as I think you were saying, there's nothing in the legislation saying that the Information Commissioner has to formulate policies on such and such or give guidance on such and such, or is there?
There are lots of powers for the Information Commissioner to produce guidance, and indeed in relation to, for example, the issue of monetary penalty notices and penalties, the Commissioner has published statements of policy. So in addition to the regulatory action policy that was handed up to the court today, there are also statements of policy about penalty and about the calculation of penalty, which sets out the Commissioner's policies. Now, of course, again, the First-tier Tribunal is not in any sense bound by those policies. You may think those policies are thoroughly bad policies, but if it wishes to say, well, I've read the policy, and the policy seems to me to be sound and provide a helpful framework, then it's open, we say, to them lawfully to do so.
And one has in this document, which was handed up, at page 27, what will be the amount of any penalty, and then steps 1 to 5 of how that will be worked out, so that there's some certainty in the marketplace about how this all works. An initial element, aggravating factors, deterrent, reducing the amount for mitigating factors, etc., etc. So you've got an outline, and you've also got from the previous page 24 and 25, when will a notice be appropriate, penalty notice, and then the kind of factors which will be taken into account. So one can see that that is the policy structure, and presumably that is also usually reflected in the reasoning in a penalty notice. It would be strange if it were not. And in those circumstances, you're saying it's not inappropriate, quite the reverse. It's appropriate that an FTT judge should look at that structure and the reasoning and take it into account and reject it if it's nonsense and not if it's not.
Yes. And
That's all you're saying.
And it goes no further than that, we respectfully say. What one can compare that to, because it's important not to overstate this, because there will be many cases, perhaps most cases, at the other end of the spectrum, where what happens is the tribunal hears up-to-date and fuller oral evidence that was not before the Information Commissioner. It could have been that the cross-examination of the director of the appellant had gone very differently, and the First-tier Tribunal could have reached different conclusions. That we've heard from the director, we've heard about the care and attention which he took to data protection issues, and we entirely accept his evidence that these materials could only have been out in the open air, the maximum given the procedures he adopted for hours or days, and therefore we view these breaches, to the extent they're breaches at all, in an entirely different way. And there would be no space at all for the Information Commissioner even to make a submission. Well, no, perhaps he ought to be paying some attention to our analysis. Such a submission would receive very, very short shrift, because the tribunal is in a better position to reach findings of fact than the Information Commissioner.
And it isn't in this case, but presumably with the background that you've told us about, if the Commissioner issued a penalty notice that was way out of line or contrary to some provision of the guidance he's already given, that in itself could be and would be a basis for a challenge in the FTT.
Yes.
But that's not this case.
No, it's not this case.
No suggestion.
So the authorities dealing with this issue are first of all Huang in the House of Lords. Huang is at tab 31, page 614. As we know already, it's about the proper approach to be taken in immigration and asylum and human rights appeals, and the legislation is in materially identical form to the legislation that we have here about the scope of the appeal. We've looked at the Immigration and Asylum Act 1999. The risk of taking what might be thought to be a cheap point, submissions have been made about the importance of this case, which the Commissioner doesn't understate, and the huge importance to many companies if a monetary penalty notice is imposed on them. But Huang is, of course, about not issues of money, important though money is, but issues of life, death, torture, persecution, and the proper approach to be taken by tribunals when it hears those types of cases. So on any view of equal and perhaps considerably greater importance. The single judgment is of Lord Bingham, and if I could ask the court to pick up the analysis at page 629. And Lord Bingham begins on this issue halfway down 629 by citing the legislation that we've already looked at, which, as I said, is in materially identical terms. And then at paragraph 11, the nature of this type of appeal is set out. So the task of the Appellate Immigration Authority is to decide whether or not the challenge decision is unlawful, as incompatible with the convention right, or compatible and so lawful, not a secondary reviewing function dependent on establishing some kind of misdirection or irrationality or procedural impropriety. It's not a judicial review. The authority must decide for itself whether the impugned decision is lawful, and if not, but only if not, reverse it. And that's the decision reached by the Court of Appeal in that case, and it's correct. Lord Bingham then goes on, paragraph 12, to overrule a decision of the Court of Appeal and a decision of a lower appellate court, another decision of a lower appellate court to the contrary. And then at the top of page 631, there is the but. After the quote, these decisions are right to recognise, see paragraph 16 below, that the judgment of the primary decision maker, that's the Secretary of State in an immigration case, on the same or substantially the same factual basis is always relevant and may be decisive. But they don't describe the correct approach of the Appellate Immigration Authority to its role, and the Secretary of State's argument to the contrary must be rejected. So we're told to look at paragraph 16 for more detail. But before we get to paragraph 16, there's 15, where Lord Bingham explains that the first task of the appellate authority is to establish the relevant facts. They may well have changed. In any event, where the applicant has not been interviewed, the authority will be much better placed to investigate the facts, test the evidence, assess the sincerity of the evidence, and so on. Now, that's essentially the same point, probably put rather more clearly, that I was just making, that there will be many cases in which the First-tier Tribunal, as the Immigration Appellate Authority, then called, has now been renamed, will be in a much better position than the Secretary of State on questions of fact, because they've heard all the evidence. Then paragraph 16 contains the detailed analysis of when the views of the Secretary of State may be relevant. The authority will wish to consider and weigh all that tells in favour of the refusal of relief challenge, with particular reference to justification under Article 8.2. Then Lord Bingham says there will in almost in any case be general considerations to bear in mind, and then there's a list of the general considerations that are routinely put forward by the Secretary of State in these types of cases, about the need for a system of effective immigration control, about consistency, and about discouragement of people breaching their leave, the importance of removing people who commit serious crime, discouraging fraud, and so on. And then between letters E and F, there are some examples given from the case law. So at letter E, there's citation of the Newey case, who was one of the leaders of the Nation of Islam. And it's then said between E and F, in which note was taken of the Home Secretary's judgment that the applicant posed a threat to community relations between Muslims and Jews, and a potential threat to public order for that reason. And Lord Bingham concludes that the giving of weight to factors such as these is not, in our opinion, aptly described as deference. It's a performance of the ordinary judicial task of weighing up the competing considerations on each side and according appropriate weight to the judgment of a person with responsibility for a given subject matter and access to special sources of knowledge and advice. That's how any rational judicial decision maker is likely to proceed. So there is said that there is a type of case, a particular example of a circumstance in which the views of the Secretary of State there about a risk to public order were properly taken into account by an independent judicial appellate decision. There's then a further example just before letter E, between D and E, in the citation of Samaru. And what said just before E was that attention was paid to the Secretary of State's judgment that deportation was a valuable deterrent to actual or prospective drug traffickers. So the view of the Secretary of State on a question of deterrence and adequacy of deterrence was properly and lawfully taken into account by a judicial decision maker. I'm not saying they had to, but it was lawful to do so. So far from always ignoring the views of the Secretary of State and starting with a clean slate, on some issues, and examples are given by Lord Bingham, the views of the Secretary of State may be relevant. Less so on issues of fact, where the appellate authority is going to, in essence, conduct a trial, but more so on issues of policy and principle. It's not an obligation to do so, and it's not deference, it's not giving up your judicial role, but it forms part of the judicial task to take account of such sources of knowledge and information. Now, the response that's put forward to Huang is to say, well, this is considering a rather different issue. This is considering whether or not it's a breach of Article 8 of the European Convention on Human Rights to deport someone. But it's difficult to understand why that assists the appellant, because even in a case about compatibility with convention rights, and of course a court is under a duty under Section 6 of the Human Rights Act to comply with the convention itself, that even in those circumstances, the court acts properly and lawfully, taking into account the views of the Secretary of State on issues such as that. Now, the approach in Huang was then adopted and approved in Hesham Ali by Lord Reed, and it was a 7-judge court, and all the other members of the court agreed on this issue at least. Hesham Ali is in tab 32, the next tab, at page 636. And the starting point is page 641, paragraph 8. And by the time that Hesham Ali had been decided, the relevant immigration legislation had been restated, and it could be found elsewhere, but the wording had not changed, and it's quoted by Lord Reed at paragraph 8, and it's in familiar terms. The analysis of Lord Reed on this issue is then begins at paragraph 39 on page 653. At paragraph 39, we're told that the nature of appellate decision making in the context of immigration involving Article 8 was authoritatively considered in Huang. And then at paragraph 40, Lord Reed proceeds to summarise Lord Bingham's decision and then expands on it and explains it further. And the relevant part for our purposes begins at paragraph 43 at the bottom of 653. Fourthly, the first task of the authority was to establish the relevant facts, which may well have changed, and they're in a much better position. And then against that, paragraph 44, fifthly, the appellate authority should give appropriate weight to the reasons relied on by the Secretary of State to justify the decision under appeal. Lord Bingham's examples are cited, including a case just between A and B about deterrence. There's then a quotation of Lord Bingham's judgment and then an explanation at paragraph 45. And the explanation is given in general terms about the nature of the appellate role. Where an appellate court or tribunal has to reach its own decision after hearing evidence, it does not, in general, simply start afresh and disregard the decision under appeal. We then have citation of Sagnata Investments, Court of Sessions licensing decision, and another licensing decision, Hope and Glory. Lord Justice Toulson's judgment is then quoted to the same effect. So it's absolutely clear, we respectfully say, that Lord Reed is identifying points of general application and general principle, because he's taking licensing cases and saying that the statements of principle in those cases are equally applicable to a legislative scheme which is materially identical to the one that's before this court. Then paragraph 46, these observations, that is Lord Justice Toulson in Hope and Glory, applies a fortiori to appeals against deportation decisions. Then there's an explanation of paragraph 46 as to why, and that's because, in essence, deportation cases involve an application of principles and rules and policies made by the Secretary of State. And here we say we're in a very similar position. Parliament has appointed an independent person, the Information Commissioner, to have responsibility for enforcing the legislation and having a general overview as to its compliance and issuing notices imposing penalties. The Commissioner has published statements of policy and approach as to how he will go about his task, and that explains what he does in general, why he imposes notices in certain categories of serious case, and the reason why he may not impose notices in less serious categories of case. And on those types of questions of judgment and on the assessment of penalty, those types of questions are classically within the scope of this analysis as to when an independent judicial decision maker may wish to pay careful attention to the analysis of the Commission. So the way the case is put by the appellant is it's very much about the impropriety of applying Hope and Glory across the piece. We say that's an entirely incorrect way to analyse the authorities. We say the proper way of analysing the authorities is to take note of the fact that we have multiple House of Lords or Supreme Court decisions on a materially identical legislative scheme relating to appeals, making points of general application about the proper approach to such appeals where there are issues of policy which are considered by the initial decision maker, and distinguishing those type of issues from questions of fact, which will generally be for the tribunal. Finally, my lord, my lady, there is the decision of the Supreme Court more recently in MS Pakistan, which I apologise wasn't in the authorities bundles, but I hope we've handed out a copy and it's on this morning and it's on the bench. As I said to my lord friend Mr. Coppell, it's fairly embarrassing that I forgot about this case till yesterday because I was in it. But there we are. It's a case about human trafficking, and it again analyses the same set of legislative provisions and explains the proper approach. The relevant part of Lady Hale's judgment begins at paragraph 11 with the Secretary of State's concession in light of Wang that when determining an appeal that removal would breach rights protected by the Convention, the tribunal is required to determine the relevant facts for itself on the basis of the evidence, albeit giving proper consideration and weight to any previous decision of the defendant's authority. Hence, it's now common ground the tribunal is in no way bound by the decision reached under the national referral mechanism. Now, that's a scheme operated by the Secretary of State for identifying potential victims of human trafficking. And then Lady Hale says that's an important matter, and then cites the views of the interveners as to the bad consequences that would have occurred if that concession had not been made. Then at paragraph 14, Lady Hale explains why the concession is correctly made, that this is the role of the tribunal was made crystal clear by the House of Lords in Huang, and then provisions we've looked at in Huang are then cited. And then over the page, at page 1380 of the report, between letters D and E, Lady Hale makes the same point that we've seen in the authorities, and she does it by reference to the Upper Tribunal's reasons, explaining that the Upper Tribunal was better equipped than the authority to make pertinent findings, that's findings of fact, and they explain why, because they've heard evidence. And then at paragraph 15, Lady Hale summarises the principles about when the independent judicial body is going to take account of the views of the national referral mechanism, Secretary of State. The proper consideration and weight which the Secretary of State says should be given to any previous decision of the authority will depend upon the nature of the previous decision and its relevance to the issue before the tribunal. And then here, the issue was essentially factual, and the tribunal was in a much better position. So again, we have the Supreme Court making clear that in a case that is appropriate, it's perfectly lawful for an appellate body to take into account the views of the original decision maker. Not in that case, because it concerned pure questions of fact on which findings of fact after a trial have been made. But again, that line of authority is confirmed in clear terms. And we also say that those conclusions on a legislative scheme in the same language as here are amply supported by the language of the legislative scheme. Given that there's, we say, 3 apex court decisions on point, too much textual analysis is maybe not required, but the language of section 163 does require an analysis of the notice itself, whether a discretion ought to have been exercised differently, whether a determination of facts is correct, which is of relevance to the decision which is under challenge. So far from starting on the basis that a notice doesn't exist or to be ignored, this is an appeal from a notice, and the contents of the notice, depending on the issue, may be more or less informative to the decision-making role of the First-tier Tribunal. Now, that is not the case in every appellate scheme. It's perfectly possible to design an appellate scheme under which the content of the regulator's decision is legally relevant. Such a scheme, in truth, is not an appeal. Such a scheme is actually a reference of a matter for redetermination by a tribunal. And there are such schemes. The most well-known one is the scheme under the Financial Services and Markets Act of a reference of a matter, not an appeal, to the Upper Tribunal, not the First-tier Tribunal. And the Upper Tribunal in such cases is not hearing an appeal. What they are hearing is a matter which has been referred to them. And because a matter is different from an appeal, it's open to, for example, the regulator, the Financial Conduct Authority, to run, providing they stay within the confines of the matter, an entirely different case. So the case in which this was established, a case called Jabre and the Financial Conduct Authority was one in which the regulator decided that it would make much more serious allegations than it had originally pursued and decided. And there was a debate as to what the matter meant, and the upshot was that it was entitled to run entirely different allegations, including allegations of a lack of integrity, which had not been made previously. That line of authority, we probably don't need to go into it, was recently approved by this court in a case called Seiler in the last few months. And I don't raise that to show that I need it for the purposes of this case, but I'm simply saying that it's perfectly possible, and sometimes Parliament does, design differently worded schemes in which one does rather put the decision of the original decision maker into a box and instead replead the case. And the rules of the Upper Tribunal in those cases don't involve the production of grounds of appeal. The initial obligation is on the Financial Conduct Authority to plead a statement of case, an originating statement of case setting out what their case is. And that is an ordinary originating type pleading under which new allegations may be made. Sometimes the Financial Conduct Authority asks for a higher penalty, sometimes it asks for different sanctions, sometimes it asks for lesser sanctions. But it's an entirely different scheme. And we've detailed the authorities and the legislative provisions in our skeleton argument by way of comparison. Just before turning to my final topic, to answer a question put by my Lord Justice Newey about the burden of proof in asylum appeals, that's dealt with in a decision of this court last year in a case called MAH Egypt. Has it been handed up?
It's not.
Yes. The upshot of this case is that as a result of retained EU law, which is reflected in the immigration rules, at the stage of initial decision making, the burden of proof is on, querying of course whether that's appropriate language, the burden of proof is on the asylum seeker to make out their case, and the standard of proof is a very low standard of proof, namely in asylum a reasonable degree of likelihood, or in human rights a real risk which is not fanciful. Then on appeal, the burden of proof is on the appellant, the asylum seeker or the human rights claimant, and the standard of proof is the same low standard of proof. And one gets all of that from paragraphs 18, 49 and 75 of the judgment of Lord Justice Singh.
Did you say 17, 18?
Sorry, 18, 49 and 75. That deals with, in respect of, first of all, burden of proof, then standard of proof, and then the position before the Secretary of State. And that probably doesn't provide much assistance to this case, having chased it down, because there are EU-derived provisions about where the burden of proof sits in those type of cases, and there is also extensive previous learning about the standard of proof, which is a special lower standard.
Why are we being referred to it?
Because
So-
I asked the
solely
question.
because my Lord Justice Newey asked if we got any assistance from cases on the burden of standard of proof in the asylum context. Just putting Mr. Lockley to work over lunchtime, I'm afraid. But it probably doesn't assist, but that
Clearly
answers.
vital, thank you.
Yeah, I'm afraid it's not vital, in fact it's irrelevant, but the point has been chased down nonetheless. The final point, very briefly, is that if the Commissioner is wrong about everything that the Commissioner has said so far, we nevertheless invite the Court to dismiss the appeal for the reasons I've already sought to identify. This is a case in which the Tribunal heard oral evidence, saw documentary evidence, reached its own findings of fact, identified and corrected mistakes of fact, identified and corrected a mistake of law, and then reduced the penalty by 2/3. And we say that's not promising material from which to suggest that the first-tier tribunal, in fact, made any of the errors of law which are suggested in this appeal.
Could we necessarily take that approach? Let's take ground 2. So suppose we concluded that the first tier had attached weight to what was said in the notice, and also concluded that the first tier was not entitled to attach weight to what was in the notice. Could we just say we'll dismiss the appeal anyway? Would we have to remit it? What would we do?
Well, in those, if you actually decided that the first-tier tribunal had actually taken account of this material, looking at the language which the learned judge used, and that was a mistake of law, then I think in those circumstances you would have to, I'm afraid, remit it for reconsideration. If you accept the ancillary points which we have made, that on a proper reading of the decision, and the judge was turning her own mind to what the correct answer was, then even if you're with my learning friend Mr. Koppel on ground 2, we would say that wouldn't necessarily mean that there had to be a remittal, but it would depend on the exact terms of the court's judgment, of course. Yeah. May I just turn my back to see if there's anything else I need to say?
Just before you do, can I mention one thing that I meant to ask Mr. Koppel about? I think I noticed somewhere in the papers, possibly in a respondent's notice, some suggestion that there was an agreed order as to no costs, whatever we decided in this case. I don't think I've seen such an order. Was such an order made, or at any rate, is it?
Sent it separately.
Oh, were we? Yes, I see.
Yes, I think what happened is, because this was an appeal from a jurisdiction in which costs are only ordered in the case of unreasonable conduct, it's open to this court to make an order under, I think, CPR 5219 to preserve that position in this court. And the parties have agreed that such an order should be made.
That's always a relief to the court, because it means that at the judgment stage we're not going to have to worry about the cost questions.
Yeah, you don't have to do it. Regardless, the parties have agreed that there should be no orders.
Yes.
In fact, that order has, I understand, been made.
Yes, I see.
Anything else? Mr. Lockley is able to assist in answering the court's question about the directions that were made below, and with your permission, I'd like to ask him to do so.
Yes, please.
Yes, just as indicated in Ms. Jaffe's submissions, there were fairly standard directions prior to the hearing. Although they were relatively detailed, they were to produce the schedule of agreed facts, which the court's been taken to, and the schedule of issues in dispute. There was also a direction for a chronology and a reading list, and a fairly detailed draft timetable. And then at the conclusion of the hearing, there were further directions for additional written submissions on the issues of burden and standard of proof, which had arisen quite late in the day, and also another issue to do with the law of agency, which the court may have seen was before the FTT and indeed the Upper Tribunal, but is no longer before this court. Those were the case management directions.
So there were no directions pre-trial about witness statements or whatever?
I don't believe so, Judge. There was timetabling of Mr. Badeo's evidence, but no one was directed to produce evidence. I see Mr. Koppel nodding.
There was a direction about written openings from the chapter.
And there may have been directions for skeleton arguments.
Yes, I see.
But I hope that assists the court.
Yes, thank you very much. Mr. Jaffe, anything else you want to say?
No, my lord, I'm great.
I don't detect any more questions. Mr. Koppel.
First of all, I agree with Mr. Lockley's recollection of the directions for the hearing that took place. They were quite detailed. Partly that was because it was done virtually, but also partly because the tribunal apprehended that it had quite a bit to get through and wanted to do it in the most effective way. But that's a correct summary. learned friend Mr. Jaffe split his submissions into 5 sections. The first was facts, and under the heading of facts, he told the court that the period of time that the material was outside or accessible was a long period, and that this was a relevant consideration. Well, the answer, Lord, is that it couldn't be that, because the regime only came into effect in May of the same year. So it was less than 2 months before the material was uplifted, and that's the only period that could be relevant for determining the period over which there had been non-compliance with the particular regulations, because prior to that they simply weren't in force. So that's a small point that I make, but it is a point of correction as regards Mr. Jaffe's submission. Mr. Jaffe then took you to the photos in the confidential bundle, that's at the end, to which I say fine, but it doesn't give the full picture of what was before the tribunal itself. And the tribunal, I think pursuant to a direction, ordered that the parties put in written skeleton arguments in advance of the hearing, what I would call a written opening. And that we did. And I would ask the court, if it's going to take into account those photographs, to look at what was prepared by the appellant there, which is in the supplementary, or confidential supplementary information bundle, although it itself is not confidential. Those are at page 34, and in particular, the section headed the factual backdrop, starting at paragraph 1138 and on to the end of paragraph 25, because that makes clear the nature of the property on which the material to which Mr. Jaffe referred you was found. You could only get access to it, a third party could only get access to it if they were a resident of the adjacent properties, trespassing by going down fire stairs into that property itself.
He made findings about this.
I'm sorry, my lord.
The FTT made findings about this.
Well, the FTT did make findings about it, and they are at paragraph 80. Well, the relevant finding is at paragraph 83. First bundle. Sorry, excuse me for a moment. Oh, sorry, I found it. In the core bundle,
Paragraph 83, isn't it?
and you see in the middle of paragraph 83, I say what the accessibility was. Well, the only point I make in relation to this is to dispel the suggestion that these were readily available to people, as it were, on the street or coming across them by chance. It would require intentionality on the person to sense trespass in order to see this material itself. That's the only point that I make in relation to that. I don't want the wrong impression to be created when looking at the photos of this material as if it was lying out, if it were lying out in the street. That isn't the case. That's the only thing that I wish to say on the first point, the first area, the facts. Next, when it comes to the law, Mr. Jaffe took you to Article 5.1e of the GDPR, but that was not part of the penalty notice. If we go to the penalty notice itself, in the core bundle at page 195, you see the basis upon which the penalty notice was issued was Article 5.1f, 24.132, and then over the page 13 and 14. 5.1e did not form part of the basis for the penalty notice itself.
I haven't read this properly. The 5.1e is referred to in A, but in a way that's not part of the complaint. Or
It doesn't it doesn't found the penalty notice.
Why do you say that?
I'm sorry, my lord.
Is it because instead of saying they had failed, it only says it's likely to have been infringed? Is that the point?
51E is one of the freestanding separate requirements in the accountability provision. So you've got 6 of them, A down to F. The only one that founds the penalty notice is F, i.e. the security, not the keeping in a form longer than prescribed. And the reason that that was mentioned is because you couldn't, because the regime had just come into force.
So I'm not in the least bit saying you're wrong, but just so I understand, we see in paragraph 2A the reference to 51F 24(1) and 32, and then we get this further sentence. It is also noted that Article 51E is likely to have been infringed. So we note that, but it's not.
Yes, and indeed, I think later on you see it referred to in a conditional sense, i.e. had this regime been in place for longer than just under 2 months, then it is likely that that would have been the case. But it hasn't been, so it can't found the notice.
Yes, I see.
Next.
Sorry, very sorry to interrupt, my friend. It may be useful to look at paragraph 95 of the first tier's judgment on this issue, where the judge explains that, in essence, that although the information commissioner said there was probably a breach, her view that there was in fact a breach.
Then the next
So,
point.
sorry, just pursuing that, that is indeed the case. So given the gravity of the contraventions, my additional finding that DDL is responsible for a breach of Article 51E. So she's referring to it in the context of penalties.
Well, I don't know that in the sense that helps the commissioner. I mean, the reality is that 51E.
Actually, it's also in 84. So she's referring back to 84.
Yes. And the reference to Article 5.2 leads me on to the next point.
But I'm not quite sure where we are on 5.1.
5.1F.
You started off by saying 5.1E is not part of the penalty notice.
It's not part of the penalty notice, and so
My
should fall.
Lord has just identified the bits, the references to 5.1E in the first-tier judgment.
And
So where does this take us?
no, they shouldn't have been there in the analysis carried out by the FTT. What I'd said previously is that there is sufficient in the other breaches, 51F and 32, that aspect, that is to say, that first question is made out. So there's no point in attacking the references to 5.1E because the commissioner is home when it comes to satisfying the first question, i.e. there has been non-compliance with those provisions in the DPA, if that makes sense.
Yes, I mean, I don't suppose it does make any difference, but I'd still like just to understand. So when the case is opened before the FTT, was it opened on the basis that there was a breach of 5.1E as well as the other provisions?
When the case was opened, Lord, we see that in the document that I just taken the tribunal to in the confidential bundle.
This wouldn't be it, would it? Because this would be your case. I'm just wondering what the Commissioner's case was.
I don't think we have that in the bundle itself. That may stand to be corrected.
I have loose here. I'm not quite sure where it comes from. Skeleton argument for the Information Commissioner in the matter of an appeal to the First-tier Tribunal.
You've got something I don't.
I see. I don't know whether you've got this, Mr. Coppell. I see in paragraph 21B, there is a reference again to 51E.
For what it's worth, my lords, my lady, it looks like in that document in paragraph 28, the Commission stuck with likely, which was the formulation of the notice. And then the view of the tribunal was that it was going to go further and find a breach. There is learning in the context of this tribunal as to when the tribunal is permitted to do that, but it's never been a ground of appeal that the tribunal wasn't permitted to do that.
Yes,
Hopefully we don't need to go into that because it's not one of the grounds
No.
of appeal.
Well, I think Mr. Coppell is, in any event, saying, well, it really doesn't make any difference to the substance of this case. So I'm just, yeah.
So we haven't made a point. There is actually later on a further point in relation to adding grounds and what have you, but not in the way indicated by my own friend. So it's not an issue that each of the matters, paragraphs in Article 5.1 is a continuing obligation on the controller that is to be demonstrably complied with. But that doesn't mean, doesn't follow from that the ICO can randomly issue a penalty notice and tell the controller to demonstrate that it must have complied with Articles 151A to F. And that is borne out by the fact that the Information Commissioner has been given powers to issue a whole range of notices: an information notice, an assessment notice, an enforcement notice. And they are there so that, respectively, the Information Commissioner can find out what's going on. So you don't just give them a penalty notice and say, prove it. Find out what's going on, to give an assessment as to what's going on, and to make a coercive order in relation to something that is non-compliant. And a penalty notice is really at the end of all of that process. It's the last step. And that is borne out by paragraph B of section 155, subsection 1. You can look at it before. I've always been concentrating on A.
Sorry, where were you taking us?
155, paragraph 29 in tab 1 of, sorry, page 29, tab 1 of the bundle of authorities.
Yep.
And then 15151B.
B for Barry.
Yep.
So, yes, you can, the Commissioner can issue it if there's been a failing under 149, that's all the various provisions in the GDPR, or the Commissioner that is satisfied that a person has failed to comply with one of those 3 other notices. So issue the information notice, issue the assessment notice, issue the enforcement notice, or any combination of them. If there's non-compliance, then you issue a penalty notice.
It's not a prerequisite to.
It's not a prerequisite, but it tells us that the correct approach is not going to be issue a penalty notice, fold your arms, and then it's for the person receiving the penalty notice, the controller, to show that they have been compliant because of the accountability provision.
I don't understand. I'm very sorry. I don't understand the submission. You accept that the things in B are not prerequisites. So the in an appropriate case, if the Information Commissioner is satisfied, you can issue a penalty notice, and then the question is, do you appeal it? You don't have an intermediate stage after the issuing of a penalty notice, do you?
No, my point, the point that I make in relation to the inclusion of paragraph B in section 1551 is it goes to what's been characterised as the burden. If the Commissioner wants to take it upon himself to go straight into a penalty notice, it is difficult to understand why the burden would be on the recipient if, in fact, what's contemplated in 1551B is that there have been antecedent information notices, assessment notices and enforcement notices.
Well, you accept that B is an alternative.
It's yes, it is alternative, but it helps us understand what is being contemplated in an appeal against a penalty notice itself. It's not that the Commissioner issues the notice and then if the appellant appeals against it, everything must be shown by the appellant itself. There was some discussion with Mr. Jaffe, as indeed there was with me, as to whether it is apposite to speak of a burden of proof in an administrative appeal. And the reality is that language has found its way into various jurisprudence, for better or for worse. But what we say is that the applicability of any statutory provision, whether to confer a benefit or whether to impose a disbenefit, will require the statutory prerequisites to be satisfied. You can't get away from that. That's how legislation works. And if there is a difference between the administrative parties as to whether one or more of those prerequisites is satisfied, then one of those parties will have to make the case, to avoid the word of burden, will have to make the case that the prerequisite is satisfied. If there's a difference between them, somebody has to pick up that requirement. And the starting point is that if satisfaction of the prerequisites confers a benefit, let's say to some sort of an allowance or what have you, then in the event of disagreement about the prerequisites being satisfied, it's for the recipient of the benefit to make the case. If, on the other hand, satisfaction of the prerequisites is the imposition of a disbenefit, such as a penalty, then in the event of disagreement as to satisfaction of those prerequisites, it's for the body imposing the disbenefit to make the case where there's disagreement, where and to the extent there's disagreement. Call it burden if you like, but perhaps that's a better way of expressing it. Perhaps that will form, after this case, part of the language of the tribunal, because I agree with the bench, I agree with my learned friend, it is a better way of describing it. But ultimately, somebody has to make the case where there's disagreement about statutory prerequisites being satisfied. Mr. Jaffe submits that the ICO agrees that an appeal to the FTT is merit-based, but then carries out, if I may say so, a linguistic analysis of section 163 to describe an exercise that's very different from merit review. Merit review means deciding afresh, and that is clear from Upper Tribunal authority, which is in the bundle, which we should look at in tab 14.14. There is the Upper Tribunal decision in Central London Community Healthcare NHS Trust and the Information Commissioner. Now, this was a monetary penalty notice under the 1998 regime. And if we turn to paragraph, it's a section that starts at paragraph 47, page 163. You'll see that the Upper Tribunal was looking at the regime under the 1998 Act, which had very similarly worded provisions to that which we are considering here. And you'll see paragraph 49 that the Information Commission had in the FTT, but not in the Upper Tribunal, advanced submissions to the effect that the Tribunal had narrow supervisory jurisdiction akin to judicial review. That, as I say, wasn't contended below, but it's paragraphs 50 and 51 which I say are important, and the correct statement of the procedure, both under the old Act, under the new Act, and that is, it's a decision to be taken afresh. And you'll see in the second half of paragraph 50 an observation or reservation that the Upper Tribunal had in relation to the now refined submissions made by Ms. Proops. It had some sympathy with Ms. Proops' suggestion that when considering evidence, we afford considerable weight to the IC's views, given the Commissioner's experience and expertise as a statutory regulator. Exactly what's being said now, 10 years down the line. If the Tribunal, that's the FTT, was suggesting, by saying it had some sympathy, that one party to an appeal should be given some sort of evidential head start in an appeal, then it was clearly wrong to do so. I'm sorry, my lord.
But as I understand the submissions against you, that is not being suggested.
Well, it's not being suggested in words, but in fact, when you unpick what Mr. Jaffe is submitting to this court, that is what is being asked and said is to be the proper approach. And more to the point, it is exactly what the FTT did from the word go in paragraph 88 of its decision. It's affording what it considers to be appropriate weight, etc. It wasn't giving complete weight because it found that the numbers of documents upon which the Commissioner's decision was predicated, some 500,000, was 8 or so times more than existed. And then you'll see there's a reference to the Tribunal's decision in Information Commissioner and Home Office, which we have under the next tab, tab 15. And in that case, the appeal provision was the provision in the FOI Act, which again is in like language. And
There's proofs again.
always. And the relevant paragraphs in the Upper Tribunal decision, the one at tab 13, really starts at paragraph 55. Running the argument again that it was, quote, classically appellate.
It's under tab 15, isn't it?
Yes, tab 15, my lord, and the page reference for the analysis starts at 190.
Yeah.
And particularly paragraph 58, 59 and 60. The word afresh is repeated there. And that's good law, and it's good law for the purposes of an appeal to the FTT under the 2018 DPA. That's precisely why, when there is an appeal against a notice, whether it's an enforcement notice, information notice, or what have you, the ICO can add matters in the appeal to what is contained in the notices themselves. It can add matters, it can add facts and circumstances, whether they've come before or after the notice itself. If Mr. Jaffe were correct, it wouldn't be open or possible for the ICO to do either of those things. So what we say is that merit review of a decision that imposes a disbenefit on an appellant involves the body imposing that disbenefit, satisfying the FTT, the statutory conditions for the imposition of that disbenefit are met. And in the case of a monetary penalty notice, that means, first of all, satisfaction of section 1551, paragraphs A or B. And secondly, satisfaction, having regard to the matters listed in Article 83, sub-Article 1 and 2, that the imposition of a penalty would in the individual case be effective, proportionate and dissuasive. And on an appeal to the FTT in a penalty notice case, it is for the ICO to satisfy the FTT of both. The say-so of the ICO, whether in its notice or otherwise, we say doesn't do the job. On an appeal to the FTT, it must be manifest from the FTT's reasons that the FTT, has independently reached satisfaction on each of the statutory requirements. And if it is so satisfied, it then must come up with its assessment of the amount of the penalty, again, in regard to 83, 1 and 2 factors. My Lord Justice Newey asked Mr. Jaffe about policies. It's more than just a function that there be policies. There's a statutory duty on the Commissioner to produce policies relating to monetary penalties. That's section 160. And subsection 7 of 160 specifies what must be included as regards monetary penalty notices in the policy. And that guidance...
I didn't get your reference, I'm sorry.
Sorry, section 160 is generally about the duty to produce policies.
And it was a particular...
Subsection 7 deals with monetary
thank
policies.
you very much.
And then section 161 makes clear that that has to be put by the Secretary of State before Parliament, and it can be disapproved by either house, I think within a period of about 40 days. So it's not just any old statutory guidance, it's statutory guidance that Parliament has given approval to, albeit through the negative resolution procedure.
And just showing I haven't kept up properly, so have we seen any such guidance?
It should be on your Lordship's desk. That's what you said.
That's the so the regulatory action policy is something
As I
put
understand
before
it.
Parliament in that manner.
That's as I understand the case.
But I understood that there's plenty more out there if one only knew.
Yes, there are there are statutory policies relating to, for example, the media. There are statutory policies required about, I think there are a total of 5 or 6 that are required in the DPA. It's scattered in the DPA itself.
Yes, I see.
I'm almost there. Huang, my learned friend took the court to Huang, and it's right, as he said, that the appeal provision which is quoted in the judgment of Lord Bingham, or speech of Lord Bingham, at page 182, is similar to that in section 163 of the DPA. So Huang's at tab 3131. And the appeal provision you'll find in the law report page, at page 182, in the bundle page at 629 in the middle of the page, adjacent to the letter E. And if you read 21.1 and 21.3 together, they come to pretty much the same as you see in section 163 of the DPA. Now, the point is that Huang was not concerned with satisfaction of the requirements of a statutory scheme. It was concerned with a review of an administrative decision and whether refusal to allow the appellants to remain would have been incompatible with convention rights. And that's precisely how Lord Bingham begins his speech. We see that paragraph 4, page 627 in the bundle, 180 in the report itself. And the critical paragraphs here are paragraphs 9 and 10. What Lord Bingham there says is 2 important steps were taken to ensure compliance with this new domestic legal obligation. That's the Human Rights Act. The first was to amend the then current immigration rules to require immigration officers, entry clearance officers, etc., to carry out their duties in compliance with the MHRA. And the second important step, paragraph 10, second important step was to enact section 65 and certain paragraphs of Schedule 4 to the Immigration and Asylum Bill. That's the appeal provision to which I've just taken your lordship and ladyship over the page 629. But even then, the task, although not directed at statutory criteria, aligns with what we say is required here. And you see that in paragraphs 11 and then over the page 631 of the bundle, at the top of the page, in the coda to paragraph 12. And then on the next page with the fifth sidebar, paragraph 15, the first task of the appellate immigration authority is to establish the relevant facts. These may well have changed since the original decision was made. So the temporal standpoint for the tribunal, whether it's this tribunal or whether it's the FTT in a data protection appeal, is the moment at which that appeal is heard. It's not a backward-looking exercise. And then you see at the end of paragraph 15, it is important that the facts are explored and summarised in the decision with care, since they will always be important and often decisive. That's what I've called, in our case, the first question. The second question, so far as it applied in Huang, is dealt with in paragraph 16. So it's going to weigh consider and weigh all of the factors in favour of the refusal of leave, which is challenged, with particular reference to Article 8 of the ECHR. And then you'll see there are 3 things which are considered as being especially important. And then adjacent to letter F in the same paragraph, paragraph 16, the giving of weight to factors such as these is not, in our opinion, aptly described as deference. It is performance of the ordinary judicial task of weighing up competing considerations on each side and according appropriate weight to the judgment of a person with responsibility for a given subject matter and access to special sources of knowledge and advice. That's how it would be done. That is apposite for the decision that was before the court in Huang, but it is not apposite where those considerations are statutorily spelled out. And
Sorry, what do you mean by those considerations are statutorily?
I mean the considerations that are spelled out in Article 83.2. Because when we turn to 83.2, which is in the first bundle of authorities,
We can leave Huang.
Can we leave one?
We can leave Huang. We can put away
Leave
bundle
one,
2
yes,
and go
sorry.
bundle 1. Yeah.
it's in tab 3, page 78. And we remember that under section 155.2, in deciding whether to give a penalty notice to a person and determining the penalty, the Commissioner must have regard to these matters. That's what's required. There they are in paragraph 2, A down to K. And what is not in that list is having regard to the views of the regulator. What must be had regard to are matters listed A to K. And as I say, that finds expression in section 155.2a. There is nothing in the GDPR, there is nothing in the DPA to say that the FTT must or it may, in addition to A to K, have regard to the views of the ICO. And all we are saying is that it's not for the FTT, or indeed a court, to read that into the legislative regime. For if there's one thing to be said about the hundreds of pages that comprise the data protection regime, is that nothing has been left unstated. There are pages and pages of the stuff. Finally, the question asked Mr. Jaffe, or Mr. Jaffe addressed, what should the court do if this court finds either or both of the grounds made out of appeal? We say the court can't be confident that had the tribunal done it in the way that we say the tribunal should have done it, the outcome would have been the same. And so for that reason, we agree with Mr. Jaffe, it does need to be remitted to the First-tier Tribunal for reconsideration in accordance with the reasons for judgment of this court. Unless there's anything further, that's all that I have.
Take a few more questions. Mr. Jaffe, I don't think Mr. Coppell has gone outside the authorities cited in his skeleton. It might be said that he's cited to us cases that had not been referred to before. Therefore, you have presumably a right of reply on the new cases, but I'm not encouraging you to exercise it in the sense that we have covered a lot of ground already.
Can I just give you a couple of sentences on one of the authorities,
Yes.
which is CLCH at paragraph 50.
Yep.
Which the court has shown, that's authorities 14 at page 164.
And it was paragraph,
Paragraph 50, my lady.
thank you.
And paragraph 50 that was relied on is a corrective to both the appellant and also the information commissioner in that case. The first is some general criticism about the use of the concept of a de novo hearing, which it said, whilst accurate, may not be helpful. We respectfully agree it may not be helpful, may not quite be accurate, because there are senses in which this is an appeal and not a complete de novo reconsideration. And so using something other than the statutory language in section 163 can be dangerous. Now, no criticism of the Upper Tribunal in that case, because the types of issues that are before this court were not before them, and it was just an attempt at a summary of what their task is, or what the first tier's task is. But one does have to be slightly careful about language like de novo and full merits and so on. The appeal is a very broad appeal on facts, discretion and law in section 163, but it is still an appeal. And then secondly, of course, there's a corrective to the Information Commissioner, that if it's suggested there's an evidential head start for the Commissioner, then that's clearly wrong, and we respectfully agree with that observation. That is not what is being proposed. Unless I can assist further, that's all I wanted to say about that authority.
Thank you very much. You won't be surprised to know that we're not going to give judgment here and now. You will receive a draft in the ordinary way, and we'd be grateful if at that point you would supply us with corrections to our typing in English, but obviously we wouldn't welcome an attempt to re-argue the case. We'd be grateful too if at that stage you would seek to agree an order dealing with consequential matters. If there should be any points on which you disagree, we'd be grateful for brief written submissions, and we would expect to deal with those points in the order that we make. I ought finally, although I know that this will be well known already to those in court, to reiterate the importance of the embargo. You will, I'm sure, have well in mind the emphasis that has been placed on it in recent times. You've helpfully, I think, provided already a list of those to whom the judgment should in due course be distributed. Were there to be anybody else who you thought ought to see it before it's finally handed down, you should of course come back to us to get permission to do that. But anyway, we're very grateful to you both for your oral submissions, to those behind you who've contributed as well, and it's all been put very helpfully for us to consider.